can the personal guarantee or personal surety can be invoked against a personal guarantor without any initiation of CIRP against the principal debtor? Is it possible in the
Yes,
law?
so like we have read the Contract Act, Section 128 of the Contract Act very specifically mentions that the liability of a principal debtor and of the surety is coextensive with each other. It is not that upon failure of recovery from the principal debtor, then we will have to approach the guarantor. Both of them can be evoked simultaneously. So, as per your question, there is no precondition of pendency of insolvency resolution process or liquidation against the corporate debtor for filing any application under Section 60, and there is absolutely no necessary to dwell into on any submission of such fault. The creditor may initiate proceedings against the principal guarantor without even invoking any insolvency proceedings against the principal debtor. He may do it after initiating insolvency against the principal guarantor, or maybe simultaneously with both. There's no bar, there's no timeline defined that how do you have to approach with respect to insolvency of a debt. Even the Supreme Court of India, in a very recent landmark judgment of State Bank of India versus Ramakrishnan, and very specifically mentioned that the liability of the principal debtor and the surety is coextensive with each other. It is joint and it is several, and it can be invoked at any point of time after default of debt.
I think this brings a very important point which you have given. See, a corporate debtor, if is having a lot of assets, fixed assets, which can be in cash, like land, building, property, etc., is there, and the lenders can go into SARFAESI without initiating the CIRP against the corporate debtor, and they can recover a lot of money out of that, because then whatever amount remains is practically either that inventory or receivables. And our experience also says that these are practically not recoverable. A very
Absolutely.
minuscule
It's a
amount is
very
recovered. It's a very good tool, as well as as far as bank is concerned, they can recover from surfacing the physical assets, and then they can go for the personal insolvency directly without initiating the CIRP, because again there is a lot of cost in CIRP involved, and they can go for a personal
absolutely.
insolvency, and the law allows that.
Any which ways, an insolvency resolution process is very lengthy and very cumbersome. It cannot be completed, and you can't have a timeline. Although we have timeline of CIRP, but in practical, we have always seen the CIRP getting extended because there's so many claims coming in, verification of so many claims, inviting applications. So it becomes a very cumbersome, very time-taking process. So in the meantime, the creditor who has advanced a huge loan of money and has to have a different or has to have an additional mode of recovery also. And if the now after this personal insolvency against personal guarantors has been invoked, I think banks are doing a great job in recovery. And plus, the loans have also become more efficacious in the sense that they are doing their proper due diligence before giving the loan, because they know that one default will also garb in their personal guarantors here. So a lot of things come at stake.